My guest today is Leanne Meyer, Investment Manager and Legal Counsel at Omni Bridgeway, a global dispute financing organisation. Leanne has over 25 years' experience as a commercial litigator at both Baker McKenzie and Gilbert and Tobin, and most recently she was General Counsel for RSL New South Wales, where she was a member of the executive leadership team and led the organisation's legal, governance and compliance function through a period of significant reform. With Leanne's unique background as a general counsel and private practice litigator, I'm curious to hear more about her move to Omni Bridgeway in February this year, and also what dispute finance can offer to legal teams and their law firms. Thank you for joining me, Leanne.
And thank you, Sasha. It's really great to have the opportunity to speak with you about dispute finance and in particular my new role at Omni Bridgeway. By way of introductory explainer, I should say that until recently, Omni Bridgeway was known as IMF Bentham, which may be a name more familiar to many. In November last year, IMF Bentham merged with Omni Bridgeway, which is a European-based dispute funder. And in March this year, the combined entity adopted the Omni Bridgeway name. As your introduction of me reveals, in terms of Omni Bridgeway indenture, I'm pretty freshly minted. I started with Omni in February this year, and I have to say the ensuing 4 months that have made for a really unique experience in meeting a new team and starting a new role. My relatively recent background as a general counsel and prior to that commercial litigator means that I come to this concept of dispute financing and how it can be used and how it can be a useful proposition for an in-house legal function with very fresh eyes. And I still look at the dispute financing concept through the lens and perspective, I think, of a general counsel. Motivation for my move: I decided to move to Omni Bridgeway after meeting with our Australian Chief Investment Officer, Tanya Sulin. Tanya's been with Omni Bridgeway since about 2007 and returned to the Australian business last year after having set up the operation in Canada. I think it was Tanya's passion for dispute financing that got me excited about coming across and being part of her team. I was attracted by the prospect of being able to continue to use my deep litigation experience and be involved in big commercial litigation matters in a kind of new and unique and emerging area. It also meant I'd get to reconnect and work with lots of colleagues, law firm and in-house from the past, which is always a nice thing to do. So put simply, dispute finance is a non-recourse source of third-party funding. It can be used by any person or business or entity which might have a potential claim or claims which it wants to pursue and will therefore of necessity incur legal expenses. When a matter is funded, a third party or the third party funder simply pays the legal costs and disbursements incurred throughout the life of a claim and recoups those costs and receives a return on that, what is an investment, only in the event that there's a successful outcome in the proceeding or in the claim. If a matter is not successful, the third-party funder does not receive any return and it doesn't recoup its costs, hence the term non-recourse. Usually, the third-party funder also bears the adverse costs risk and is responsible for meeting any adverse cost order.
I hear a lot about dispute finance and funding in relation to class action litigation. What other applications does it have?
So look, class actions is definitely, as you've hit on, an area where funding and financing is best known and associated with. And Omni Bridgeway is certainly well known for class actions in Australia. But the class action space or sphere is becoming a much smaller proportion of funded cases and is really now only one of the many types of claims that are suitable for funding. Increasingly, to answer your question, finance is being sought out and utilised in a diverse range of dispute areas, including, and this is where I predominantly come in, commercial litigation broadly, all facets of single party commercial litigation, contract disputes, competition and consumer disputes, breach of fiduciary duty claims, intellectual property matters. My starting with Omni is testament to this shift. I personally am not a class action lawyer, and my particular remit is a focus on these matters where dispute finance can be used and used well outside the traditional area of class actions.
Legal teams at the moment are under a lot of pressure with their budgets, and I can start to see some of the incentives for using dispute finance if they've got limitations on their budgets. But I'm curious to hear from you, What are some of the reasons that in-house legal teams use dispute financing?
This is the part that's still pretty near and dear to my heart, because I still recall the conversations that go on internally between legal teams and finance teams and the executive management teams. The legal teams have always been, and increasingly so, as you say, under pressure to essentially do more with less, to contribute to the revenue generation strategies, to outsource less, to do more with internal resources. But, oh, by the way, we don't have the capital to increase your legal team, so the pressures are increasing. The reasons why and the benefits of dispute financing for in-house legal teams, I think, are twofold, and they operate at a macro and a micro level. So there are financial upsides, revenue generating upsides of dispute financing for the organisation as a whole, which is obviously the paramount and fundamental reason why any legal team would be considering bringing claims. But then there's also the benefits at what I call the micro level of dispute financing for the in-house legal function internally, in being able to provide a solution to the business for unlocking valuable litigation assets which sit clearly within the purview of the legal function, and they are few and far between. And I have to say, pausing here, before I started to really think about dispute financing and its application, I hadn't really exercised my mind that a litigation claim was in fact a valuable asset that could be realised. Just to go back to the macro level, for the company, dispute financing allows claims to be pursued and the asset to be realised without the company bearing the traditional costs burden, the burden of the downward drag on the company's profit and loss and financial performance that paying legal expenses for a prolonged period invariably has. Legal costs in the dispute financing scenario simply become someone else's costs, and so therefore don't impact the company's profit and loss performance, which is particularly important and relevant in the ASX listed company space. Additionally, in the event of a successful outcome, the company retains some of the financial upside in the receipt of a judgment or a successful settlement return, which can be shown as an extraordinary profit. And thirdly, in pursuing litigation, the company lays off the traditional and significant litigation risks of loss and therefore adverse costs exposure.
How does the relationship between the funder, the claimant and the law firm work, Leanne?
The relationship between the funder and a claimant and a law firm is really best described as a tripartite relationship. A litigation funding agreement is the document that governs the relationship, and that's entered into between the funder and the claimant. The claimant retains the law firm in the usual way and instructs the law firm in the usual way. The funder receives legal bills from the law firm and pays the bills on the claimant's behalf, generally on the way through the matter. All three parties work together in the case management and cost management sense to a greater or lesser degree in project managing the matter, and that's all a matter of negotiation.
One of the questions that I have about this process is really that sense of control, and so I'm curious to hear about whether the law firm or the in-house legal team lose control, or how does that work?
That's a really frequently asked question. To answer it in a word, no. Having a funder involved does not mean that the in-house legal team or the law firm would lose control. The claimant or the plaintiff instructs the law firm in the traditional sense, and that's the way it works. The funder has involvement to a greater or lesser degree as agreed between the parties in the strategy and case management and cost management, sure, but it is the claimant from whom the law firm takes instructions. And in the specific example of settlement, it's worth clarifying and pointing out that the litigation funding agreement does set up a structure in the event that there is an irreconcilable dispute about to settle or not to settle. History shows that provision is very rarely called on because the parties pursue the matter with a common interest and a common end goal.
I'm a complete newbie in this area, Leanne, and I'm curious about costs. How does a funder get paid?
The specifics of this, how a funder gets paid, or I suppose more accurately, the returns to the funder, are pretty bespoke and are really subject to negotiation between the three parties at the outset. The terms of the return and what the return looks like to the funder are certainly way more flexible now than has been the case previously. And although there's no hard or fast rule, generally speaking, the way it works is that in return for funding the costs and disbursements and taking on the adverse cost risk, the funder's return is calculated as either a percentage of a resolution sum, and that means a judgment or a settlement sum, so an agreed percentage. And the percentage is to be negotiated. It used to be traditionally that it was a ballpark or hard and fast 35%. It's not the case anymore. It is truly negotiable. So it's a percentage to be negotiated. Alternatively, sometimes the return might be calculated as a multiple of the project costs. And sometimes it's a combination of both. And generally speaking, what it looks like depends on the risk profile, and every case has a different risk profile. In the case of a successful outcome, the funder will receive that return and recoup its project costs. In the case of an unsuccessful outcome, then it gets nothing. So that's really a broad brush of how the funder's costs or returns on investment are calculated.
In this environment where the economic pressures are just so much more significant than they have been in the past, I can see the appeal of dispute financing. So I really appreciate you taking the time to talk with me about that today.
Thanks, Sasha. It was really good to talk and have that opportunity.